Good morning, ladies and gentlemen, neighbors, friends. My name is Winston Heron. You've seen my preview on POA Reform at gmail.com, and I'm here today at the suggestion of my son, Ken Heron, to populate my channel. My YouTube channel, and I do best if I'm reading from a script. So I want to introduce you to the subject of POA reform by a letter that I've written to Representative Kevin Brady, Senator Brandon Creighton, editor of the Houston Chronicle, Nancy Barnes, and emailed to the offices of the same folks where I had them, plus Beanie Adolph, who is the Houston representative for the HOA Reform Coalition, to Evan Smith at the Texas Tribune, and to the Golden Hammer, which is a Montgomery, Texas publication by Eric Yolick. It starts off by explaining why I have been so intense on pursuing an effort to reform the way the Texas justice system handles matters of POA, property owners associations, and homeowners associations. It begins with, Gentlemen and Mrs. Barnes, my recent venture into the Texas system of justice has brought me face to face with a group of attorneys, politicians, and judges in Montgomery County that has given me cause to bring to your attention a situation facing all Texans regarding the role that property owners associations and homeowners associations are playing in the governance of local subdivisions and housing complexes throughout Texas. It appears to me that the Texas Property Code has abdicated the responsibility of government to these associations and given impunity of prosecution to the Board of Directors for violation of bylaws and deed restrictions by which they have both a fiduciary and moral obligation to abide. Furthermore, there doesn't appear to be any Texas state, county, or local agency or authority responsible for oversight of the actions of POA/HOA boards or their management companies, while some continue to hire attorneys to create bylaws that enable them to rig board elections and extort money from honest property owners. Rigged elections and the fact that there are no term limits for board members have enabled the same corrupt members of our board in Point Aquarius, in Montgomery County, to remain in office wasting property owners' money on the same attorney and corrupt management company for at least the past 9 years. I cite my own case as an example of entrapment by the Texas system of justice, whereby for the last year I have been pursuing transparency and accountability from the Point Aquarius Property Owners Association Board of Directors that has to date cost me in excess of $15,000 of my retirement savings in addition to hundreds of hours of my personal time. Senator Creighton, you may remember me standing up waiving $7,000 cash in appeal bond fees during your conversation with Mr. Evan Smith of the Texas Tribune in the Woodlands last year. I was on my way to Justice Court Precinct 1 to post that cash bond, thinking that the court's judgments were so egregious that there was no way I could fail in my appeal. Wrong. My complaint to the State Commission on Judicial Conduct regarding Judge Mack's judgments and conduct during my bench trial was answered several weeks after submission with a boilerplate, unsigned, confidential letter dismissing my complaint while offering me the right to appeal within 30 days. I'm sorry I didn't copy my complaint before hitting the submit button, because the only record I now have is the complaint number. This all began with a simple request to the Board of Directors to allow me access to inspect the books and records of the association in accordance with the statutes cited in the Texas Property Code. My request was prompted by a statement from the association president, Lawrence Vasslet, who stated that, quote, about $50,000 had been spent by the association on legal fees, end quote, in an attempt to restrain one Point Aquarius property owner from offering his home to short-term renters, such as were renting via Airbnb or VRBO in Point Aquarius. The Texas State Supreme Court has recently addressed the matter of SDRs versus HOA POA interest. The answer to my request was provided by the association's management company and was not consistent with my request, and resulted in my having to sue the POA in justice court to obtain access to same. I then found it necessary to appeal 2 unfavorable judgments from justice court to county court 2, thereby exposing me to over $17,000 in court costs, appearance bonds, and my attorney's retainer fee. Judge Laird offered that I had the opportunity to represent myself pro se, understanding that my attorney was requesting an additional $10,000 retainer before taking the case to trial on appeal. A series of procedural missteps in my pro se representation resulted in another unfavorable judgment from county court. My only recourse at this time has led me to request a criminal activities investigation of the association through District Attorney Brett Ligon's office. I can only hope that evidence I have accumulated in the course of my pursuit of justice is sufficient to obtain indictments from the Montgomery County Grand Jury prior to the November 2018 elections. I am fortunate enough to be able to withstand the financial, health, and mental stress of this process. The course of my personal investigation into the operation of our county, state, and local governments has given me reason to suggest that you may want to address these issues in your own campaigns for re-election. Sincerely, Winston C. Heron, with my address and email. With that, I'm going to close this session so that it doesn't extend beyond more than 8 minutes, which is now. Thank you.